Remote town. I'd just like to read over some of the guidelines for tonight's meeting. Recording procedures. The meeting will be recorded in both video and audio formats. The administrator, Michael Simmons, Director of Information Technology for the town, will be monitoring our online meeting. A link to the recorded meeting will be made available on the town's official website after tonight's meeting. Audio control settings. All virtual attendees will be muted by default. Members of the town council and staff will be unmuted if they are attending the meeting online. Authorized presenters. The only individuals authorized to give presentations are Attorney Paul Jessel, our town attorney, and Attorney Franklin Pillacy, who is a past town attorney and a historian on water and sewer. No other attendees are permitted to give presentations. Video preference for council, commissioners, and staff. Council members, commissioners, and staff are generally expected to keep their video enabled throughout the meeting unless participating via telephone. Public discussion protocols, how to participate after the presentation. In-person speakers will be called upon first. Indicate your intention to speak by approaching the podium here to the right and waiting for the microphone to be available. Virtual attendees, please use the raise your hand feature to signal that you would like to speak. Be aware that we do not have a feature to identify the order in which you raised your hand. We will do our best to choose you in that hierarchy of order. Virtual individuals will be unmuted by the administrator and notified that they are recognized to ask a question or make a statement. Virtual members of the public should feel free to leave their video on or off. However, they are asked to turn on their video when speaking. A picture tells 1,000 words and can be useful in conveying your meaning. If video is not available for you, you will not be precluded from speaking or providing public testimony. Identification and speaking limits. Prior to speaking, when you approach the podium, identify yourself by stating your name and home address. Address your comments or questions to either one of the designated attorneys or to the meeting's moderator. Time for individual public commentary will be limited to 2 minutes. A second opportunity to speak will be granted for an additional 2 minutes after all initial speakers have concluded. Public commentary is confined to the subject of the City of Waterbury versus the Town of Watertown water and sewer rate case. The code of conduct, disruptive behavior at a public meeting refers to actions or conduct that interpret the orderly flow of discussion, prevent the exchange of diverse opinions, and impede the achievement of the meeting's objectives. Disruptive behavior may result in your removal from the meeting based on the recommendation of the meeting moderator. The purpose of the public discussion. This discussion is not a debate between parties. It serves as a forum for the town to inform the public and, if practical, answer questions. This outline aims to provide clear and organized guidelines for the meeting, ensuring both efficiency and public involvement. Again, welcome for come to the meeting. We have members of our town council up at the tables. We also have members of our water and sewer commission, as well as Attorney Pillacy and Attorney Jessel. Attorney Pillacy, I'm going to turn it over for you to make the presentation.
Thank you, Mr. Manager, and members of the council, Water and Sewer Authority, and members of the public. My name is Franklin Pillacy. I'm an attorney practicing in Watertown for many years, and I've been involved as a sort of an assistant or consultant to the town attorney and the attorneys at Merthyr Kalina, who are the main attorneys that are handling this matter for the town of Watertown. I was asked a number of years ago when this case first started to assist with some of the historical background of the water relationship between Watertown and Waterbury and the sewer relationship between Watertown and Waterbury. And That background information is critical and really dictates how this case has proceeded so far and pretty much tells us what we have to do going forward. I selected, along with Attorney Jessel, a number of documents that we could include in handouts to anybody that wants to gather those handouts. It consists essentially of some of the key parts of this case in writing. There are certainly dozens and dozens of documents that have been prepared by Watertown and submitted as part of the court case. All of those documents are available to anybody that requests those documents. The documents that are available in the handouts include essentially a status report of this case that goes back to 2019, somewhere around April of that year when this case first started. And that document with the historical background included a number of attachments. The key attachments to that document include the background of the Waterbury water system and the general statutes and contracts that go back to that time period of the early 1920s that are crucial to understanding of the history of the Waterbury water system as it exists today and the Town of Watertown relationship with Waterbury. There's a second and third document that are available that is an affidavit that I prepared for the court case that explains in affidavit form the relationship with respect to the water system, and a second affidavit with respect to Watertown's relationship with Waterbury with respect to the sewer system. The next document that we provided in the handout is an important document for everyone to understand. And there were really two Superior Court decisions in this case, not one. Most of us are familiar, and most familiar with the most recent court decision from this summer that was unfavorable in many respects, and probably in all respects. However, there was an earlier court decision that was decided about a year or more before that. And that decision was based on the same information that was provided to the trial court in the main trial. And the judge in the Superior Court at that time, a different judge, ruled in favor of Watertown based on a lot of what I'm going to say right now, because that's part of what was presented to that judge the first time this case was litigated. It's really the same litigation, but it's a different part of the same litigation. And we also provided a copy of the trial brief that Watertown submitted in the Superior Court following the trial that occurred in April and May of this year, and also the decision by the trial court. And it's a chore really for some of us to read the brief and the trial decision and compare the two. But Watertown, in my opinion, had some very solid arguments and still has. Those arguments are still preserved and will be presented on appeal. First, I want to go back and begin with the history again of the Waterbury water system and Watertown's relationship. Watertown has been purchasing, as far as the Oakville district is concerned, and all of the area of Watertown outside the territory of the Watertown Fire District, has been purchasing all of its water from Waterbury since at least 1939 by virtue of formal contracts. There's evidence that Watertown, again, acting by the old Oakville Fire District, purchased water from Waterbury as many as 10 or 15 years prior to 1939, but there's no formal contract that can be located, but there is reference to earlier water supplies to the central part of Oakville, meaning Main Street and Davis Street. Those are the streets that are mentioned in an early document that I have located. During all of this time period, Watertown purchased water. And again, the Town of Watertown is the successor to the old Oakville district. I'll mention that a little bit later. But Watertown has been purchasing all of its water for all of its water customers through a series of contracts. And those contracts were based upon Watertown being billed for water pursuant to written contracts. And there is statutory basis that, in our opinion, mandates that water rates be wholesale rates, not retail rates. And by wholesale rates, we mean just that, what everyone thinks of as a wholesale price or a bulk price, and what sometimes we call a cost basis. In other words, the water billing is based upon the cost of Waterbury supplying the water to the Watertown water system. And I'll talk more about that later. But this goes back to the early years of Waterbury first having a public water system. The first reservoir that Waterbury had was created in 1867. And it's the East Mountain Reservoir that's still there, but not used. They then quickly ran out of supply, and they built two new reservoirs immediately thereafter within a very short period of time. It was called the Cook Reservoir and the Prospect Reservoir. That still wasn't enough water. And around the mid-80s, they started pumping water out of the Mad River to supplement the existing reservoirs, which again proved not adequate, particularly as Waterbury was then growing, as we all know. Waterbury then began searching for a water supply that would last for the long term. Waterbury asked the state legislature to give Waterbury permission to establish a water source with reservoirs and so forth in Litchfield County. In 1893, Connecticut legislature granted Waterbury the authority to acquire land in Litchfield County. And at that point, it was not really limited. It could be almost anywhere in Litchfield County. But they used that to build the Branch Brook Reservoir, which is, and an early transmission line from that reservoir. So probably sometime a little bit before 1900, Waterbury was transporting water from the Branch Brook Reservoir to Waterbury through a main that generally runs down Thomaston Avenue into Waterbury and is still active today. It was a very short period of time before Waterbury again had insufficient water supply, particularly during drought conditions. Waterbury was again looking for more water. So Waterbury, pursuant to the original grant of authority, built a second reservoir called the Morris Reservoir. And that fed into the Branch Reservoir, sometimes called the Wigwam Reservoir. And as the time period went by, and by that a very short time period, we got up around 1921. And Waterbury still did not have enough water. I'll back up one step. In 1909, the legislature passed an act that somewhat limited Waterbury's ability to range throughout Litchfield County. They were prohibited from taking water out of Bantam Lake or out of any portion of the Naugatuck River that could have been accessed at that time. So in 1921, Waterbury went back to the legislature and asked for permission to take water out of what is called the Chippewa watershed. The legislative delegation from the Chippewa region, Town of Washington region, opposed that legislation, and it was stalled. Waterbury then approached Washington officials, and a contract was signed that allowed Waterbury to take water out of the Chippewa watershed. Once that contract was signed, the Washington area delegation withdrew its opposition to the 1921 legislation. The Town of Washington contract was significant because it led to the Public Act of 1921. The significance of that Public Act can be traced back again to the Washington contract, because I review those two documents as critical events here. In both the Town of Washington contract, it expressly states that any water that Waterbury obtains pursuant to that contract is to be shared with the Town of Watertown. The 1921 Public Act, which was adopted about 6 weeks after the Washington contract and after the Washington delegation withdrew its opposition, expressly states that Waterbury may sell water to any municipality through which the transmission lines to Waterbury are located or within which the Waterbury reservoirs are located. And the Watertown connection was solidified initially by those two documents from 1921. But the statute in 1921 is critical to this whole history, and it's critical even now to the present litigation. That statute provides that any water provided to Watertown must be provided pursuant to a contract at rates that are just and equitable. And Watertown and Waterbury, prior to the present case, had a series of water contracts beginning in 1939, and through that contract lasted until 1988. And those rates were based on a wholesale rate. And the 1988 contract, I'll talk about more later, but that also provided that the rates would be wholesale, but it was tailored to a cost basis. And I'll talk about that again later. But our relationship that followed the 1921 legislation and Washington Act always contemplated Watertown would have the right to receive this water, and Watertown has received water throughout this time period. Those are generally the public acts that began this process. Immediately after that public act, Waterbury further expanded its water system. The first thing they did was they built the Chippewa Dam, which is on the Chippewa River in the Woodville section of the Town of Washington. And they built an underground tunnel from that Chippewa Dam to a location immediately above the Morris Dam. And that underground tunnel has transported water continuously from 1923, the date the tunnel was finished, to the present time. The present location of that tunnel hasn't changed, but in 1942, Waterbury built a third reservoir at that same location in Morris and Litchfield, and that's called the Pitch Reservoir. So that tunnel now discharges directly into the Pitch Reservoir, which in turn discharges to the Morris and in turn to the Wigwam or Branch Reservoir. That watershed in the Chippewa area was about 37 square miles or thereabouts. The dam was completed. The watershed again was established, which was again their secondary major watershed. That watershed in Chippewa region was further expanded. The Chippewa Dam, by the way, was fully completed in 1933. And then by 1964, Waterbury acquired an additional 10 square miles of watershed above it. That watershed is about 10 square miles or thereabouts, and it extends all the way through Warren into the town of Goshen and ends right up a little bit past Woodrich Lake, right on the edge of what's Tyler Lake. So that's how this watershed that Waterbury now uses was established. It's significant because Watertown's position has been throughout that Waterbury doesn't have any water source within its geographic territory. 100% of Waterbury's water supply comes from Litchfield County based on statutes that contemplate Watertown would share that water and mandate that the price of that water must be based on a contract that is just and equitable with respect to rates. I just want to talk about the transmission of this water. Again, beginning in about 1895, Waterbury had one transmission main, but thereafter, in about early 20s, Waterbury built a second transmission system that initially, from the mid-20s until about 1948, consisted in part of an underground tunnel called the Steels Brook Aqueduct. That transported water from the dam at the present location of the filtration plant, which again is in Watertown, to a location at the intersection of Fernhill Road and Northfield Road. That tunnel, from there, it was piped through transmission main to Waterbury. In 1948, that tunnel started to collapse, and Waterbury then built a 36-inch main for transmission all the way from the branch reservoir through Waterbury, to Waterbury. That line comes down Northfield Road. At Northfield Road or Wilson Street, it hooks a left and proceeds directly down Main Street to Carvel, heads up Candy Hill Road, and then cross country into Waterbury. Watertown accesses its water supply. There are other locations that Waterbury supplies water to Watertown. One is at Fernhill Road, which feeds the water tower on Buckingham Street. But almost all the water, except for that tap at Fernhill Road, is accessed through a water meter at Carvel, 63 and 73. That's where the bulk of the water comes out. There's a couple of other small places where water comes out, but not enough to worry about. So obviously, the filtration plant, when that was built, and I'll talk about that in a minute, is located in Watertown. There's 705 acres of watershed area owned by Waterbury that's located in Watertown. And the transmission main, at least the main transmission main, which is the biggest transmission main of the two by far, runs all the way through Watertown, almost from one end to the other. And those are the physical connections that Watertown has with the Waterbury system, and back up and support the legislation that was passed that authorized the water to be shared with Watertown by contract at rates that are just and equitable. Now, in 1939, the water system for the Oakville section was in charge of, or within the jurisdiction of, the former Oakville Fire District. The Oakville Fire District was organized somewhere around 1910 in that time period, but it really didn't have its own source of water, and they used Waterbury water again for some small territory. But the first written contract between Watertown and Waterbury was signed in 1939. And that kind of, following on those statutes, set the tone. And it basically provided that Watertown shall purchase all of its water from Waterbury, and Waterbury shall sell water to Watertown to the extent that Watertown needs that water. So that contract provided for a bulk rate, but not necessarily cost-based. It was based upon the same amount or rate that Waterbury charged to the biggest users of the Waterbury water system. And at that time, as we know, it was a significant number of factories, such as Chase, Scoville, Anaconda, and so forth. So it was a bulk wholesale rate that was the same rate as the major water users in Waterbury, and that rate was always considered to be a just and equitable rate by both the city of Waterbury and the town of Watertown. That contract lasted until, again, 1988, and I'll come back to that. But there's historical significance here because at the same time period that Waterbury was establishing its watershed in Litchfield County, the Oakville Fire District could have done the same, but the decision was made that it would make more sense to join the Waterbury system, and that's what was done. For example, the Watertown Fire District consists of a territory within the center area of Watertown that is approximately 5% area-wise of the town of Watertown. The fire district was first organized around 1900, but in 1913, the legislature approved a new charter with new authorities for the Watertown Fire District. Pursuant to that charter, Watertown Fire District had the right to take water out of Litchfield County. The fire district established in 1924 a well field of significant size in Woodbury. That well field to this day supplies the Watertown Fire District water. It's pumped to a holding tank off of Route 6, and from there accesses into the fire district water system. In 1957 or thereabouts, the fire district again wanted to supplement its water supply, and they built a reservoir in Bethlehem, and that's a significantly sized reservoir. There's two reservoirs that serve to help resupply and recharge the Watertown Fire District system. One is Judd Pond, and one is the Bethlehem Reservoir. They both transport water to the well field through streams that enter into Nonotuck River at the well field location, and in turn, water is diverted into recharge basin that sits over the wells to further keep that system going. But the point is that the fire district took advantage of an opportunity to get their own water supply in Litchfield County, which municipalities in that time period could do that. But the time period of anyone else now trying to get their own water supply through such a special act legislation is not likely to occur. So again, our main water supply was pursuant to that contract in 1939. The rates were wholesale rates. The contract provided a series of continuations or until terminated, and beginning in 1979 and within a few years after that, Waterbury began a design to build a water filtration plant at its present location off Route 109 in Thomaston is the access point, but the filtration plant itself is located in Watertown. At the time that filtration plant was being designed, the capacity had to be established. Waterbury called Watertown, and based on one phone call, they asked Watertown, how much capacity do you want to reserve in this filtration plant? Any number that you give us should be based on a 35-year lookout estimate, because that's the only amount of water that you will get through this plant. If you exceed the reserved gallonage that is being built for you, Watertown's water rates will double for anything over that capacity. So Watertown, based upon that discussion, reserved 3 million gallons of water a day. At the time, Watertown was probably using maybe in the high 800,000 gallons a day. But the superintendent of water and sewer at the time wanted to make sure that he didn't underestimate, because he was told to plan for 35 years. which he did. The total capacity of that filtration plant is about 38.5 million gallons or somewhere in that vicinity, which meant that Watertown's capacity reservation is approximately 8.75%. And that was significant because Watertown was required to pay its proportionate share of the cost to build the filtration plant, which was about $35 million. So Watertown had agreed that it would pay its share of the capital cost to build the plant. And the plant was built. There was a series of delays, but it was eventually completed probably sometime around 87 or thereabouts, 86. It was completed and put in line. Watertown's share of the cost was approximately $2,600,000, somewhere in that range. And Watertown paid its share of those bonds beginning from the date the bonding was put in place. In 1988, the parties negotiated a new contract to supply water to Watertown. That contract contained very, very specific provisions with respect to the cost or rates that Watertown would pay for water. And it was based on what we call a cost-based. And that means the cost that Waterbury incurs in providing that water to Watertown. And again, this water doesn't get anywhere near the city of Waterbury before Watertown accesses the transmission mains and takes the water out. The cost base was established by a chart of accounts called Appendix 2 to the 1988 agreement. That appendix listed every accounting chart for tracking every dollar of costs to the city of Waterbury to operate its entire water system. And then there were two separate columns, one for any component or portion of that water system that Watertown used. For example, the cost of maintaining the dams, the cost of maintaining the filtration plant, the cost of maintaining the transmission main to the extent that we were using it, and so forth. So if we put it, it also required that Watertown continue to pay the capital cost of the plant that I already talked about. But the operation and maintenance component that was used to establish Watertown's rates was strictly governed by what portions of the Waterbury system Watertown used, and all the other portions or components of the Waterbury water system that Watertown does not use. For example, the distribution system within the city of Waterbury, the operation and maintenance, again, its own billing system, its own maintenance division, pipe repair, all of those different components, including the capital improvements and maintenance of its existing infrastructure to the extent that Watertown doesn't participate in that. So that 1988 contract had very specific provisions of how Watertown's rates would be established. The rates were pursuant to a contract, and the rates were just and equitable because they were limited to the portions of the Waterbury contract with respect to Watertown's actual use of the Waterbury system, the part that Watertown used. It wasn't long after that agreement was signed where the peace did not last with Waterbury. And that resulted in a multi-year dispute over water rates between Waterbury and Watertown. And some of that dispute, I'll give you the highlights of what that dispute was all about. The first part was that Waterbury never maintained its accounting for the water system in accordance with the chart of accounts in the contract. The second problem was the contract required Waterbury to conduct an audit, an annual audit, and provide that to Watertown. They never provided an audit. The third problem was that during that time period, in the 80s and 90s, that Waterbury took $3 million a year from water rate income and put it into its general fund to offset tax increases. Waterbury also took a similar amount of money out of water rates for city ratepayers, sewer rates, and also put that in the general fund. So the ratepayers, both Watertown and Waterbury and Watertown, were compromised in that regard. The next financial adverse impact to Watertown occurred because Waterbury bonded the full $35 million to build a filtration plant before construction started. Waterbury invested all of that money and took the investment income from those bonds for several years before the money was needed to construct the plant. And all the investment income was put into their general fund. It wasn't used towards the construction of the plant as it should have been. The next significant event occurred when the plant was nearing completion. Waterbury sued its contractor over delays, breach of contract, and similar issues. Waterbury, in that lawsuit, recovered approximately $8 million. All of that money went into Waterbury's general fund. None of it was used to pay off the bonds. If that money was used to pay down the bonded debt, then Watertown's share of 8.75% of that bonding debt would have been gone. But they didn't do that. So with all of that information, Watertown wrote to Waterbury on a regular basis and demanded a dispute resolution process that was set out in the contract. And that essentially called for mediation. And if mediation didn't work, a court case could follow. Waterbury never began that mediation process. Watertown wrote to Waterbury probably about twice a year during that entire time period, which went on for 8 or 9 years. At the same time, when we could not get Waterbury's attention to follow the contract, at least the financial provisions of the contract, Watertown, acting by the superintendent of water and sewer and its finance director, did an internal study and determined how much, in their opinion, of the Waterbury water bill was justified and how much was beyond any amount that Watertown should pay under its contract. That amount was 75% of the amount that was being billed. So Watertown began a period of about 7 years of paying 75%, which Watertown documented as the reasonable cost. And as the years went by, if you asked Waterbury how much Watertown owed, they would say about $2.5 million. If you asked Watertown what was owed, our finance director calculated that Waterbury was overpaid by approximately $300,000. So we had an almost $3 million difference in billing and what rates could be justified. And that went on through the late 90s and early 2000s. During those early 2000 years, again, we demanded meetings with Waterbury, and occasionally we actually had one. We probably had 4 meetings in total. And during those meetings, we presented all of the arguments, all the issues that I just recited, which were the problems of Waterbury overcharging Watertown. We believed the amount overcharged at that time was probably $300,000 to $400,000 a year for a number of years, which we can all do the math. It was a lot of money. So eventually, during 2006, leading into 2007, I was dealing with probably the 3rd or 4th different city attorney. And when I asked for another meeting, I got a phone call in response asking if we wanted to settle that issue. So we said, sure. So I informed the then town manager and the chairman of Water and Sewer that we may have an opportunity to settle the case. Waterbury asked me what we would offer to settle. So we contacted Waterbury and said, we will settle this billing dispute if Waterbury forgives all money, including interest, that Waterbury claims is owed by Watertown. And in return, Watertown would give up its claim that Watertown had overpaid. At that time, it was probably an 8-to-1 or 9-to-1 ratio of where we were. The next day, Waterbury agreed to settle the case, and a formal vote to settle was obtained from both Water and Sewer Authority and Town Council. The significant part of this is that Waterbury got caught. They refused to acknowledge that until around 2007. When the 2007 settlement agreement was signed, significantly, there was a new chart of accounts established as an appendix to that 2007 settlement agreement. And that was a chart of accounts that accounted for all of the actual costs that Waterbury was at that time charging their water system to these new accounts that was different than in the earlier appendix. And again, it was designated which portions of the Waterbury water system Watertown used and which portions Watertown did not use. I've already discussed generally which two components or sides of that ledger were used by Watertown. And again, Waterbury charged in accordance with the new chart of accounts, which again continued the cost-based billing rate, again pursuant to an amendment to the 1988 contract. Now, the 1988 contract was a 25-year contract with 2 automatic 10-year extensions, except either party could terminate at the end of the 25 years or at the end of the first 10-year extension. Waterbury terminated the contract at the end of the 25 years. And in 2013, Watertown entered into a new contract. The new contract did not expressly call for a bulk rate or a cost-based rate or a wholesale rate. However, the amount of the cost of the water in that contract was right in line with what Waterbury had been paying. Watertown had been paying all along under the old 1988 contract and the 2007 amendment. So even though Watertown did not like the transition away from an express cost-based contract, Watertown was presented with a contract that contained 2 problems. One, water contracts of this nature typically run 25 years or more, and typically, from our perspective, should have an equitable and just rate. But because the rate in the contract didn't rise to anything that could be legally challenged, Watertown accepted the contract. And those rates were very favorable for the 5-year life of the contract. It had a specific dollar amount for every CCF of water, which is the measurement that is used in the industry for water billing. In 2018, it was time to renew the contract. And Watertown began to negotiate. I was not involved in that, but I'm certainly well aware of it. And Waterbury didn't really want to negotiate very much. They said, you're going to pay a different rate, and the rate that we're going to charge you, this wasn't much of a negotiation, by the way. It was, this is what we're going to bill you. We're going to charge you the same CCF rate that we charge our retail users in the city of Waterbury. And that was problematic from Watertown, from Watertown's perspective, because it meant that Watertown already pays for its own waterworks system. It has, through the Water and Sewer Authority, it has its own administration, it has its own maintenance workers, it has its own contractors that assist with the less than routine or non-routine maintenance. It has its own billing system and its own customer service. So Waterbury wanted to charge, and in fact did charge Watertown, the same price for water that it charges to its own customers. So once Watertown gets that water bill, it has to add on to that all of the cost of Watertown operating and administering, maintaining its own system. So in effect, the Watertown rates being charged was substantially higher than anything that was being paid by Waterbury residents. And it a little bit slightly more than doubled what Watertown ratepayers would be asked to pay. So at that time, the Water and Sewer Authority was aware certainly of this case, and they amended their rate structure in order to start banking some money in the event of an adverse outcome in this case. Now I'll start talking a little bit about the sewer part of this. Waterbury had no sewer plant really to speak of until about the early 1950s. At that time, Waterbury was accepting sewage from Watertown. The rates were never an issue. But the first sewer contract that Watertown had, also a sewer contract, also provided for what we call a bulk or wholesale rate. And that rate, and let me back up a little bit of history here. The main transmission line from Watertown to Waterbury was completely updated and rebuilt in the early 1950s, probably around 51 or thereabouts. And that followed a contract with Watertown for sewage treatment from, I believe, around 1949. And that contract provided a certain rate that was estimated to be cost-based, and it provided for a specific dollar amount once the Waterbury filtration plant was finished in the early 50s. And by that, I mean the sewer plant. And that contract worked from around 1949 or thereabouts until again in 1988. And that contract also acknowledged that a substantial amount of the cost to build that sewer transmission main from Oakville to the Waterbury sewer plant was paid with grant money and so forth that was intended and did benefit both Watertown and the City of Waterbury. Again, in 1988, a sewer contract was negotiated for a long period of time at sewer rates that were again made sense because they were based on a wholesale or bulk rate based on Watertown paying its share of any capital costs and Watertown paying its proportionate share of the operation and maintenance, sometimes called the usage costs of that system. But again, it did not include Watertown paying for any component of the Waterbury sewer system that Watertown did not use. And that worked for a while. And somewhere around the late 90s or thereabouts, the state DEP mandated that the City of Waterbury do a major upgrade to its sewer plant. That upgrade cost $81 million, which was funded by low-interest loans from the state DEP. Watertown began a series of negotiations with Waterbury, and we had to revisit the issue of how much capacity does Watertown want to reserve. So we didn't want to over-reserve like happened with the water, but we also knew we had to reserve extra capacity because DEP was in the process of dictating that the Watertown Fire District sewer plant would have to be closed, and that sewage would also be included in Watertown sewage transmitted to Waterbury. So Watertown negotiated a sufficient capacity without a whole lot of additional capacity, but to include the fire district sewage, which it now does. Several years after that agreement was signed, probably less than that, probably closer to months, DEP ordered the fire district sewer plant closed. Now I'll back up one more time. In the late 70s, when DEP again worked on upgrading that transmission line, they required an agreement between the town of Watertown and the Watertown Fire District that basically said that the fire district had to build a connection to the Watertown sewage system going to Waterbury that could be accessed in the event the fire district plant failed or was ordered closed. So that connection was already done in the late 70s. So in around 2007 or thereabouts, the fire district plant was closed. And since that time, the sewage from the fire district joins the sewage from Watertown, which goes to Waterbury. There are agreements in place that the fire district paid its proportionate share of the cost to build that sewer plant, and the town of Watertown paid its proportionate cost. So similar to the filtration plant, the sewer plant capital costs, Watertown paid approximately 10% of that, and of Watertown's share, the fire district paid approximately 35%. So all those bonds to construct that sewer plant were finished, completed about 3 years ago. So that's the sewer side of it. In 1988, again, we had a contract. The rates were cost-based. It was acceptable, and there were no problems. But in 2013, when that contract was terminated, a similar situation occurred where a new 5-year contract, that's the only term that Waterbury would provide, was set in place. And for 5 years, from 13 to 18, Watertown had rates that worked fairly well because they were cost-based, they were deemed just and equitable. So for approximately the 78 plus year time period, Watertown had contracts with Waterbury, but sewage treatment, water supply that were based on written contracts, that were based on rates that were just and equitable as required by the underlying statutes, both the legislation that authorized taking water out of Litchfield County and in accordance with the other statutes that are out there that talk about intermunicipal agreements for the supply of water and treatment of sewer that are supposed to be based on rates that are just and equitable. When Watertown continued to pay the old rate and not the new rate, that number coincidentally came out about 75% in the beginning. But in fact, Waterbury's number was probably a little bit higher than that. And matter of fact, the rates that Waterbury was seeking and is still to this day seeking are about double your water rates and about 3.5 times higher than the sewer rates. So Watertown resisted paying those rates for 2 reasons. One is the rates were not based on a contract as mandated by the legislation. And number 2, the rates were including Watertown subsidizing in a very big dollar amount Waterbury's own water and sewer system. And had Watertown paid those rates, then Watertown would be subject for indefinitely, maybe, who knows, maybe 100 years. Watertown would be responsible to pay the same retail rate plus fund its own distribution system, and taking into account that Waterbury in 2015 had a consultant study tell them that their rates were too low. So the rates that were deemed too low were already costing Watertown a double and tripling of its respective rates. Waterbury has a second study that was done within the past year or so that tells them they need a substantial increase in their water and sewer rates, which means had Watertown simply paid the rate that Waterbury was demanding, the water and sewer rates to the customers of the Watertown system would almost certainly be going up again. So even within a few years' time, your rates could go 3 to 4 times higher what you were paying under the old contracts, with absolutely zero justification to demonstrate that those rates are just and equitable water rates. When the present court case started, Watertown, again, through Attorney Jessel, had almost monthly been sending a letter to Waterbury asking for negotiations to negotiate a new contract, and implicitly protesting that Watertown was not prepared to pay those exorbitant increases, but more significantly, any such increases that came in the future. So Watertown would have been tied to every retail rate paid in Waterbury forever. So Watertown, again, continued to pay at the old rate. It's not like you're not paying anything to Waterbury. You're still paying the old rate, and our experts concluded that even at that old rate, Waterbury is making a profit off of the town of Watertown with respect to water and sewer. Now we'll back up. Where did the Waterbury rates come from? And there are statutes in Connecticut that water authorities use to set rates. And those statutes are 7239, 7244, and 5 in that area. And those statutes give a water agency the right to establish rates following a public hearing and so forth. And there's almost no real right to appeal those rates by anybody. But even if you could, I don't think you'd get very far. So when the 2018 or 13 contract ended in 2018, Waterbury just said, we last raised our rates for our retail customers in 2015, so that's your base rate going forward. And that again meant a doubling and tripling to Watertown's rates, not taking into account future rates that we knew were right around the corner, because their operation and maintenance system is deemed inadequate, and there's pick a number, but there's staggering amounts due to address deferred maintenance within their own system. So on the scale that Watertown would have been required to pay, had Watertown simply accepted those rates, it would not have made any ratepayers happy. And in my opinion, it would have been absolutely reckless for Watertown to pay or agree to pay and agree for its ratepayers to pay what Waterbury was seeking. So again, Watertown paid 75%, and Waterbury filed the lawsuit in 2019. And Watertown has contested that lawsuit. And again, the first legal test of that authority, Watertown prevailed. In the most recent trial, Watertown was of the opinion that the judge didn't pay much attention to the legal arguments that Watertown had made. And I urge any of you to read the trial brief that is available in here that Watertown submitted. And if you follow the legal arguments, it doesn't give you all the history here, but it gives you much of the history and much of why Watertown is of the opinion that they should not have to pay the Waterbury rates. That legal brief ties together all of the Watertown arguments by tracking the statutes that are pertinent and the mandatory requirement that rates be just and equitable. One more little twist here. The 1921 contract that authorized Waterbury to expand further into Litchfield County was titled an act to amend the charter of the city of Waterbury. So it's an integral part of the Waterbury's charter. That charter provision expressly requires water to be shared with Watertown as an additional municipality, and a municipality through which transmission lines flow and within which the plant is located at rates that are just and equitable. So our argument is Waterbury ignored all the legislation that allowed them to take water out of Litchfield County, and Waterbury ignored its own city charter in trying to unilaterally increase these rates to the town of Watertown. While the litigation was pending, again, we had that summary judgment trial, and the judge, based on the same information, ruled in favor of Watertown. In addition, before the trial started, a mediation schedule was set up, and we met and attempted to mediate, or fancy word for negotiate, a resolution of the rate issue without having to have a full trial. Waterbury appeared and participated at the first session, but gave little indication that they were willing to do anything by way of negotiating against their retail rates. They basically said, even to the mediator, literally, those are our rates, you have to pay them. And the lawsuit, when it was brought, it was based on the statutes that allow municipalities to set rates for its retail customers. It was never intended, in our opinion, to be used for an adjoining municipality, which has its own statutes, and in this case has its own 78-year history of accessing this water through contracts at rates that were wholesale or bulk, and we determined just and equitable. So Watertown's argument was, we have a almost 80-year history of being supplied with water pursuant to rates set by contract that are just and equitable. And Waterbury never really responded much to that. They said, we set our rates and you're going to pay the same rates for any water that you take as our retail customers pay. And again, that includes all of the components of the Waterbury system, much of which are sadly deteriorated. And on top of that, then you have to charge your customers for all the cost of maintaining, operating your own water system. So that is where we were at the time of the trial. As we all know, the judge didn't see it our way. We are of the opinion that the judge did not pay attention to the history, but more significantly, the history's fine, but the statutes that authorized Waterbury to take water out of Litchfield County were not taken into account in that decision. At that point, Watertown again could have done one of two things. Watertown could have, okay, we're going to pay you what we owe you, and going forward, we're going to pay you whatever you charge us. Had Watertown agreed to do that after this court decision and not filed an appeal, then the ratepayers would have been stuck with an immediate increase of double or triple, with a almost certain further increase within 12 to 24 months, and subject to any further increase that Waterbury needs to charge its own ratepayers to deal with all of the deteriorated conditions within the Waterbury territory. So there was really not much of a decision to be made. That Watertown had no choice but to file an appeal and try to have an appellate court review the Superior Court decision. Now, timing wise, there's also the possibility that regardless of what the appellate court does, there's one more level of appeal. So regardless of which side wins the appellate court case, there's the possibility of a further appeal to the Supreme Court. Now, we believe that it's likely, not guaranteed, but it's likely that the Connecticut Supreme Court may take this case directly from the appellate court. So there will never be an appellate court decision. In other words, if the Supreme Court views this case as something that eventually they're going to have anyway, and of something of great municipal importance, they may just take the case directly. So the appeal that's pending now may end up directly into the Connecticut Supreme Court. Time-wise, regardless of if we have an appellate court case here or a Supreme Court case here, it's not likely that there will be a decision within probably, I estimate, 16 to 24 months. It could happen faster, but most significant cases in the appellate court or the Supreme Court will take minimum of 12 to 16 months. Sometimes after a case is fully briefed and argued, you can wait up to a year for the decision itself. So I estimate 16 to 24 months before Watertown receives a decision on its appeal. So in the meantime, if Watertown wants to continue to challenge Waterbury's billing methods, we feel you have no choice. The amount of money that Waterbury claims is owed right now is a pittance compared to what the ratepayers will have to pay if Watertown does not appeal, or if Watertown ultimately does not prevail on the appeal. So that's pretty much where we are right now with this case. Watertown is still going to pay, as far as I know, this is not my decision, but probably going to continue to pay the same rates until this case is finally resolved. Now, I've been asked, what is the likelihood of winning the appeal? And when you have a court case, especially today, it's very difficult to predict what any one judge or any appellate panel will decide. I think Watertown has a very solid argument and a very solid chance to win this appeal. I'd hate to put a percentage out there because I don't want anybody running around Waterbury what I think of their chances or Watertown's chances on appeal. But I will say that I think there's an excellent chance that an appellate panel or Supreme Court panel will take seriously all of Watertown's legal arguments, which were not properly even discussed or taken into account, in my opinion, in the Superior Court case. So that's the background, and that's what we're up against. The key decisions really were made when the old Oakville District in 1939, and even prior to that, decided that water would come from Waterbury and they would not seek any opportunity to acquire its own water source within Litchfield County. It's been asked, does the fire district have enough water to supply Watertown as opposed to Watertown buying water from Waterbury? And the answer is not really. The town of Watertown already purchases a relatively small amount of water directly from the fire district, but the fire district does not have the capacity to supply Watertown with what Watertown uses on a daily basis, which I believe is just under 1 million gallons a day. So Watertown's usage of water really hasn't increased as originally anticipated. Again, part of that is nobody has big factories using a lot of water anymore. But Watertown has increased the number of water customers since the 1988 contract by a substantial number. But yet the overall water usage hasn't drastically increased very much. So that's pretty much how we got here. That's pretty much where we are right now. Again, there are handouts for everybody that are available either tonight to pick up that include the original background that was written at the beginning of this case, the copy of the pertinent statutes that allowed Waterbury to go into Litchfield County, the sewer history that allowed Watertown to contract with Waterbury for sewer, the Superior Court decision on Waterbury's motion for summary judgment, which essentially Waterbury argued that there's no possible factual issue here. As a matter of law, Watertown has to pay our rates. And the judge said, no, all of these other considerations, including the pertinent statutes, should be taken into account. We also provided as a handout a copy of the legal brief that Watertown filed in the present appeal, in the Superior Court case, which we feel was not adequately taken into account, and the trial court decision. So all of those handouts are available tonight. Any other documents that I've referenced, they're all available through the town manager's office. I'm sure the town manager has all of these documents on file to back up everything that we're talking about. So I think I'm pretty much, well, let me mention one other thing. Right now, the authority is looking to raise rates again, which it's probably time to do that anyway, but obviously with this Waterbury decision out there, additional money has to be raised and put aside, put in the bank, depending upon the possibility of a worst case scenario. And Watertown has engaged an expert to assist with that rate study. It was mentioned, I'm not sure, maybe at the zoning meeting, that why would Watertown use the same company that the trial judge didn't pay much attention to? And the answer, in my opinion, is, I wasn't involved in this decision, but I support the decision, is that company is nationally recognized by every possible size of a water agency anywhere in the United States. There were two principals of that company that testified. One of the principals that testified, the older gentleman, we were a little bit disappointed. But the second representative of that company that did testify, we thought was totally excellent. Very knowledgeable, came across knowledgeable. I think at that point in the trial, it seemed to us that the judge seemed to be favoring anything that Waterbury said and not necessarily favoring or even leaning towards Watertown's positions. But the expert that's involved right now in your rate study, if it's who I think it is totally competent, great experience, great credentials, and is very knowledgeable of your situation with respect to rates, as well as being a national expert. So I think you're in pretty good hands as far as your ongoing rate study is concerned. Now, I will remain and try to answer any questions that anybody wants to ask about our relationship historically with Waterbury and what the present situation is. But I just want to conclude by making it clear, in my opinion, nobody in Watertown did anything wrong. The Town Council, Water and Sewer Authority, they were aware of this. They were aware of the certainty of exposing the ratepayers to immediate doubling and tripling of rates and exposing ratepayers to increases anytime Waterbury wants to increase its rates. It would have meant that Watertown ratepayers were subsidizing the Waterbury water operations and Waterbury sewer operations to the tune of millions of dollars a day for services that Watertown does not get. Watertown does not get any services with respect to the retail or operational aspects of the Waterbury water or sewer facilities within its territory. So with that, I'll be happy to try to answer any question that anybody has. If it's a question I can't answer, I'll try to defer that to someone else here, such as Attorney Jessel or the town manager or the Water and Sewer Authority superintendent. But please, as Mark said, if anyone has questions, please come up and we'll do our best to try to answer them. If
you'd like
anyone
to
has
ask-
comments, those will as well be accepted, I gather. Correct?
That's
Okay.
correct. Comments, questions? Just a reminder, there is a 2-minute limit for us to get through initial questions or comments. And then we could circle back for a second round of 2 minutes. Before we take questions, Attorney Jessel, do you have anything to say or can we go right to questions? Okay. If anybody'd like to come up and ask a question, we'll do in-person questions. Please come up, form a line at the podium and take your turn, please. I will give you just a reminder at about 1:45 so we could keep the same process. Thank you. If you could just get closer to the mic and if you would state your name and address, that would be great.
Hello? Yep. I'm Charlie Shields, 141 Merriam Lane, Watertown. Was just wondering, in all this process, we have Watertown and we have the fire district. Are there any differences in how this ultimately affects people in the fire district aside from Watertown as a whole?
Yes. Because again, all sewage from the fire district territory is now transported in the same transmission line to Waterbury for treatment. Presently, the fire district, for every sewer bill that Watertown gets, the fire district is responsible based on percentage of usage. And that's a gallonage estimate, or it's actually a gallonage based on actual readings, is approximately 37%. So the amount of the total bill that you may have read in the newspaper, the fire district is on the hook for about 38% of the sewer component of that bill.
And the water is all supplied by the fire district to the fire
The fire
district
district,
residents,
100% has its own water supply.
so they don't get,
They're not part of this.
they're not part of the water portion
Yeah.
of that.
Correct.
sewer.
They're not part of the water portion at all.
All right, thank you.
Can you hear me? Okay, you said that you did, that no one did anything wrong, and I see a lot of things wrong, but I won't be able to do it all in 2 minutes. Starting with name, sorry, Catherine Camera, Cottage Place, Oakville. So I'm sorry, that's going to disrupt my 2 minutes. So what I see something very wrong. Number one, you're talking about now raising our rates to make up some money. Well, why didn't that happen in 2018 while this was pending?
It actually did happen. There was.
Yeah, mine went up about $30. That
There
really
was
wasn't enough.
a rate increase to begin banking money in case of a worst case scenario. But because this dispute has lasted as long as it has, in hindsight, that rate probably could have been raised more and probably will be now.
Okay, well, and the other issue is, why was this never in an audit? For 3 years, our audit has said there was no material cases pending. I did an FOI request to find that our audit was closed last year, this year. And then the letter came that should have went to the auditors that said this was a material issue. So what's going to happen to our bonding when they find out that we've never talked about with our audits, that we've had this case, not only this case, there was another case that never shows in our audits that we had this material case pending. So I think we're going to have a problem going forward with bonding and everything. I mean, this is going to be a disaster.
I don't have the answer to that, so we'll just accept that as a comment.
Well, is
And
someone else going to answer that? Because I thought we were getting our questions answered today. I didn't think we were just asking you for answers.
I would
thought it
defer
was the
that
whole board.
question to the town manager if he's prepared to answer it, or perhaps get you a better answer at
Okay,
another
well,
time.
So I don't want to answer incorrectly, but I believe that was noted in our audit.
it
But I
wasn't.
would have to check and I'll get back to you.
When will you get back to me? Because this whole audience is not going to know the answer to that. If you're going to privately answer me. How's this audience going to know the answer to that question?
Well, to be honest with you, I can't answer you right now. I've told you, I've I cannot answer you. So for me to answer you now is not.
I
appropriate.
understand that. I asked you when you will answer and how you will answer so that the people here, will it be on the website? How will the people know the answer? We came here prepared to get answers to our questions, so I'm just asking you, how will we all know the answer?
I will make sure that's noted on our website.
Thank
So
you.
that'll be the easiest way. Thank you for bringing that up.
Richard Rosansky, 35 Reynolds Street. 2 months ago, I approached the town council with about 16 questions about how the rate users would be affected by this situation if we lose this appeal. You have not addressed a single one of those questions that I asked you. You took my questions, you didn't answer a single one. So let me ask you one question. The town manager has said we have approximately 50% of the 18.8 million in reserve. Is that money directly attributable to the ratepayers? Or has that come out of other accounts? Because if it's attributable to the ratepayers, it will have a direct effect at reducing their arrears. If it's not, we're all still on the hook for 18.8 million plus the $9,000 every day we go forward in interest that we're accruing on this account. Can anybody answer that?
That money is in water and sewer authority accounts. It's not in town funds. Town funds are not included in that money that's set aside.
So is that money directly attributable to each and every water and sewer user ratepayers account so that we can give them a credit on the arrears should we lose this appeal?
That money is set aside to be used towards any amount that is ultimately determined to be owed by Watertown to Waterbury as a result of this case.
This is a pass-through event.
Excuse me?
This is a pass-through event. That means the town of Watertown has to pay Waterbury the settlement. But the ratepayers, everybody in this room, has to refund that money to the town of Watertown.
I'm not sure I understand your question.
In other words, the $9 million in reserve fund will not help anybody in this room in their arrears that we're going to have to pay Waterbury.
It will help everybody. It will help every ratepayer in Watertown because that portion of any ultimate debt that is determined owed by a court will be funded with that money. And that will offset any additional money up to that amount that is needed from ratepayers.
So
Mr.
how do you
Rosinski, your
allocate
time
that
is
to
up.
Each and every rate.
Mr. Rosinski, be happy to come up and finish the question.
We can't.
David Mango, 240 Riverside Street, Oakville. Years ago, we had a sewage treatment plant, and they put the sewer interceptor in from the sewage treatment plant behind Seymour Smith, down Rockdale Avenue, across Main Street, down by the postie shop, down to alongside the bridge by in front of the pasta store, down that little road there by them two old factory homes, in Mosgrove Field, down to the back of the pin shop pond, down through the river, down to the pin shop down by high-end auto, and into the river and down there. And then they took the sewage treatment plant, and I was at a town meeting, they're gonna demolish the sewage treatment plant. To me, that's a mistake. This town makes a lot of mistakes. You should have stood self-sufficient. I told them Waterbury could jack up the price to whatever they want, and we'll be up shit creek without the paddle. Now we're in this predicament. Nobody says nothing to us all this time, right? How about all the people in the last 10 years that sold their houses, right? And they contributed to the sewer and restaurants and factories and buildings and everything else. What do we got to do? All these people that sold their house, we got to pay the premium for them. You got some thinking to do before you start charging people what you're going to do. this is a hard situation to figure out.
Mr. Mango, you have 15 seconds, please.
Pardon?
You have 15 seconds left.
Okay. Do a good job, though. A baby repercussion.
Hi, I'm Cynthia Tunn, Litchfield Road in Watertown. I want to compliment Attorney Pilsey on his knowledge of history here. I think it's remarkable. But I'm very concerned because if he has all that knowledge, does everybody else have it too? Number one. So when decisions are being made, is that history passed along to everybody else? Number two, this is a symptomatic situation. I see time after time where we have problems in this town that are not necessarily being solved in a proactive manner. There's a lot of reactionary decision-making, and I think it would be better if we looked at how to do things more proactively. And number three, has anybody ever contacted our state representatives to see if they could amend legislation in order to give us a solid ground legislatively? Because one of the things that was brought out here is how Waterbury had the legislative support to build the water supply, getting the water supply out of Litchfield County. Can't we go back to the state and see if that can be amended? And wouldn't we want to enlist the help of our state representatives in getting this accomplished? Has anybody ever thought of that?
Well, Watertown would welcome any assistance it can get from our state legislators. But Watertown believes that the statutes that are already in place that were followed directly by Waterbury and Watertown for almost 80 years that protected Watertown sufficiently during all of that time period against what I call retail or rogue rates. That those statutes work very well, the existing statutes. And
Clearly, oh, I'm sorry. I only have 2 minutes to talk. You got a lot longer. Clearly, it seems to me that sometimes the attitudes of leaderships within a town or a city change. And clearly the attitudes of Waterbury toward Watertown has changed. So they don't care about the history. They don't care about us. So we have to take care of ourselves, and we have to look for a solution outside of what is normal. So wouldn't one of those solutions be to talk to our state representatives and urge them to bring this matter to the attention of the legislative body and actually make a change to the existing legislation?
that is a good idea. It absolutely could not hurt. But bear in mind that Watertown has been trying consistently for over 6 years to negotiate with Waterbury based on the statutory criteria.
And excuse me, and that's the problem. This is the way it's always been. So we're not going to change it because change is scary and change takes time. And now we have to think in a different kind of way.
This time,
And
your time is
yes,
up.
okay. Thank you very much.
Thank you.
Okay, Victoria Dodona, Concord Drive. I have a question. Some of us on Concord Drive or Lexington sewer and water came through a few years ago. I decided I didn't want to hook up into it. So I'd like to know where does this leave us who have decided not to hook up? I'm happy with my well.
You're not is this on?
Here, use this.
You're not purchasing any water or sewer services. So therefore, this rate increase doesn't impact on you at all.
Okay, I'm still uncomfortable paying a $2,000 every year just because it came through and I'm not in the system. So that it's in itself seems unfair to me. That's besides paying my taxes.
The sewer benefit assessment that I believe you're referring to is again has nothing to do with the city of Waterbury. It has to do with the Watertown Water and Sewer Authority. Whenever a sewer improvement is made available to new properties, those new properties are required by statute to pay a portion of the cost of building that sewer extension. And that cost is usually determined taking into account the total cost of the project and the appraised value of your property versus not having the sewer available to you and then having the sewer available to you. That benefit to your property is there, whether you take advantage of it now or someone does in the future. It's completely outside the scope of this present dispute with Waterbury.
I'm sorry, but I don't agree with that.
My name's Bernie Karashki, 869 Bunker Hill Road. Obviously, that's one of my neighbors that I don't know, but that's she. My question is, in anticipation, let's say that there's an additional assessment that has to be made to cover the cost of what's in arrears. Was it going to be equally assessed to everybody that was part of the water and sewer, that has water and sewer?
I would have to defer that to the Water and Sewer Authority.
Well, my question is, and it follows a little bit of what this young lady prior to me was talking about, because we at the Bunker Hill and Concord extension program, we've only been online since September of 2019. And what you're addressing now is, from what I read, it starts back in April of 2018. So from a percentage wise, if you look at the number of months that we've had access to the water and sewer compared to everybody else, it's about 80% of that time. So I would submit that if there is an additional assessment, that those of us in the Bunker Hill Concord extension should only be having to pay 80% of that cost. And I submit that to you for your consideration. Thank you.
Thank you.
Thank you.
Is there anybody else that would like to go up for the first time? Sir?
Good evening. My name's Adam Simonson. I live at 58 Winding Brook Farm Road, Watertown. I have a degree in civil engineering. I've spent the last 25 years in the water industry. I worked for the largest private water utility in New England. I hadn't really focused on this issue till recently, but I did want to offer a couple thoughts just from my personal perspective. First, when you look at the court decision, it's pretty clear that what they've said is that Waterbury isn't charging enough money, even in the new proposed rates, to cover their costs of service, right? And so just from a fact perspective, from my opinion, even at the new proposed rate, Watertown's probably getting a deal, right? In the sense that even where Waterbury's collecting from its residents and from the other towns, it's still not covering its costs of service. So there's going to be future rate increases coming from Waterbury eventually to close that gap, right? So that's coming one way or another. Secondly, I think we're 100% correct in that Watertown has to charge its own rates on top of whatever it's paying from Waterbury to cover the costs of the collection system, distribution, customer service, et cetera, right? And really, we shouldn't be responsible for those similar sort of costs coming from Waterbury, right? I mean, that in my mind is a fairly solid argument, right? But one of the things that when I looked at some of the stuff from the court case, one of Waterbury's proposals that they had in there around rates did eliminate those costs, right? And then what they did is they replaced that with a series of costs that really reflect the risks that Waterbury carries as being the provider of water and the treater of that sewage, right? It's a significant amount of risk to run that filter plant, to run the sewer treatment plant, to figure out the capital upgrades and all of those pieces that they're not asking Watertown to figure that out. They're asking Waterbury's figuring that out, right? And when you want to think about how do you compensate somebody for risk, it's usually a financial arrangement, right? You buy auto insurance to protect yourself from risk, right, et cetera. And so their rate proposal itself to me was not a completely unreasonable argument. I think there's a lot of room to argue about the math, and whether the buildup is exactly correct, but it wasn't unreasonable. And then the last
Sir,
thing I just
we-
wanted to
we
add
have the
is
15 seconds, please.
throughout my career, I spend a lot of time, like I said, dealing with water and sewer rates. Litigation rarely comes out good, right? It produces a winner and it produces a loser. And I really think we got to figure out a settlement path, because it's not just solving this current issue, right? As we said, the rates are going to keep going up from Waterbury. So we really need to find what's the right long-term framework and a long-term solution here. And I think, continuing down a litigious path, in my opinion, is probably not the best idea. Thanks.
Thank you.
I'll try to answer a couple of those points. Firstly, Watertown has constantly been prepared to negotiate a higher rate than the rate that was set in the 2013 contract. Watertown recognizes that a higher rate can be justified and would be no negotiated if Waterbury would negotiate. The second part of it is that Watertown, regardless of what the rate is for the water, is already obligated and has been for decades to pay its proportionate share of any capital costs that Waterbury incurs in the water works or the sewer works. For example, there's some indication there's going to be a further upgrade of the sewer plant relatively soon. Watertown will certainly pay 10% of that. That's never been in dispute. If the filtration plant, again, that's goes back to the mid to later 80s, requires major upgrades at some point, Watertown will be paying 8.75% of that. That's not part of the present dispute. The second point about the provider, in this case Waterbury, being entitled to some monetary number to take into account the risk that Waterbury has previously incurred and continues to bear to keep this system going, is already taken into account. The earlier contracts provided the cost-based rate plus 10%. And that's standard in most waterworks systems where you have intermunicipal, or in some of the bigger states, intercounty agreements. Sometimes it could be slightly higher, but if there's any one number that you see over and over again, it's whatever the rate is plus 10%, which is considered the risk factor in establishing what you would pay to the provider of the service. So Watertown has been paying that right along. So we've always paid something for the risk, and we've always paid our contractually agreed portion of the capital costs to both the water system, and by that we mean mostly the filtration plant and any major upgrade to the water tunnel or the water dam. The last time Waterbury spent a lot of money on the Chippewa Dam, it was as a result of the lawsuit between the City of Waterbury and the Town of Washington. And my understanding is those upgrades that were like part of settling that case after it went to the state Supreme Court, that upgrade cost was paid by state grants. So neither Waterbury nor Washington paid for that. was paid by state grants, but we are paying our capital costs to the penny, and we're paying the 10% risk number. But we agree, Watertown has always been prepared to negotiate a higher rate than the 2013 contract rate. Response from Waterbury is over and over again, these are the rates, and they've refused to discuss anything less than the rate that they're billing. I hope I covered some of your points. Thank you, sir.
Is there anybody else that would like to speak who is here? Anyone else like to speak? If there's anybody online that would like to speak, please raise your hand and we will address the questions as they come in. If there's anyone online, if you'd like to raise your hand, please do so and we will try to answer your question.
Okay, I have Megan Monette.
Go ahead, Megan.
Yes, can you hear me?
Yes, we can.
Yes, thank you. My question is, if the appeal process is not a guaranteed win for the citizens of Watertown and Oakville, why would we waste the monetary resources that can go to settle the issue with Waterbury? And my second question is, and how is going through to a possible Supreme Court case going to benefit the town overall?
Okay, I will try to answer that. Again, Watertown would much prefer to settle this case than to continue the litigation. That's been true since before the case began. It's been true since before the 2013 contract ended. Waterbury has refused to enter into a good faith negotiation at any rate other than the retail rate that they established in 2015, which by implication means you would be left with that rate and any increases to that rate forevermore if this isn't challenged. Now, the second part is the reason to litigate the case is because it's really the only choice available other than agreeing right now that everybody that's a ratepayer is going to pay 2, 3, 4, or 5 times what you're paying now and be subject to these future increases. In other words, if you don't challenge this issue now, it can never be challenged. Now, again, I think there's a good chance that an appellate court or the Supreme Court will pay attention to Watertown's solid legal arguments. But I do not think that an appellate court or the Supreme Court, as the case may be, is ever going to set the actual rates. What we're asking is to rule that, number one, the rates established pursuant to the 2015 rate increase for Waterbury's retail customers are not justified against the town of Watertown. And we're asking the court to take into account the other historical statutes that Watertown has mentioned, that we believe a part of the history of this water system. And again, Waterbury doesn't own any water. They have the right to take this water out of Litchfield County, subject to the provisions of the statutes and the agreement from the town of Watertown. Again, that means at rates that are just and equitable and established pursuant to a contract, not a unilateral decision by Waterbury. We again think there's an excellent chance that a higher court on review will rule that this decision was not based on pertinent statutes and will reverse the trial court. That's our hope. That doesn't mean that we will have a new water and sewer rate. It means that that Waterbury will then be forced to enter into good faith negotiations, which we've been seeking all along. But Watertown has no choice. Nobody in Watertown did anything wrong. You have to challenge this now, or for the rest of the history of this relationship, you can never challenge this method of Waterbury establishing rates for Watertown. Again, our hope is to reverse the trial court decision, which would mean that Waterbury must negotiate rates that are just and equitable. That would certainly involve some increase in water and sewer rates, but it should not be an endless supplement of Waterbury's costs by the ratepayers in Watertown.
Well, I understand. Can you hear me, sir?
Yes.
I understand what you say, Mr. Pillacy, but again, if we do in fact lose, how is Waterbury will never come to the table for a quote fair and equitable rate increase. If we do in fact lose at the appellate level or the Supreme Court level, the increases are going to be that much worse. Plus, we will then be responsible for arrears and interest. Am I wrong?
You may be very well be correct, but the only alternative is to abandon any defense and immediately be subject to the present increase that's being sought and any future increase that comes along down the line with no opportunity to ever challenge a rate in the future.
But if we lose, that's exactly what happens. I do understand your theory and your thought process, sir. I do, absolutely. But I just feel like the only ones who are going to lose in this, regardless, are going to be the citizens of Watertown Oakville.
Well, in my opinion, Watertown has no choice but to defend its position, which is solid based upon statutes and a 78-year history of working properly with these statutes. And again, if you don't challenge it now, it can never be challenged. And the $18 million number that's claimed now, or million or so that's in rates, is a lot of money. Multiply that over the next 50 years.
Oh, absolutely. I agree. But if the rates that were imposed by Waterbury to begin with were that unjust and unequitable, I don't think Wolcott and Naugatuck would have been on board to just pay it without any sort of renegotiation as well. What makes Watertown that much different from the other towns that are paying the current rates?
Okay. Number one, the other towns use a minuscule amount of water. It's barely on the radar compared to the amount of water that the other towns use. Number two, and most significantly, the other towns are not mentioned either expressly or implicitly in the 1921 legislation that allows Waterbury to access this water. The other towns are not mentioned in the Town of Washington contract with Waterbury that allows water from the Chippewa and the Carnes Reservoirs watershed. And the other towns do not have any portion of Waterbury's watershed or filtration plant or transmission line within the borders of those towns. And about 15 years ago or so, there was a major litigation that went on for many months of trial between the City of Waterbury and the Town of Washington over allegations that Waterbury violated the terms of that Washington contract by not leaving enough water in the Chippewa River during drought conditions during the summer season. At that trial, everybody acknowledged, including Waterbury significantly, and the court, and even the Town of Washington attorneys, that Watertown was different. Watertown was expressly not a target of that lawsuit. But the Town of Wolcott, to a lesser extent, Middlebury, they were targets of that lawsuit. I represented Watertown during that trial, but I was mostly monitoring it, and I made a closing argument based on Watertown's position at that time, as did Wolcott, but I don't think any other town participated by representation. But the other part of that is all of this water is regulated by DEP, and DEP decides what towns can be serviced from what watersheds, from different watersheds within the state. And after that case, Wolcott has never been able to increase its water supply beyond what they were using at the time that that trial started. So Watertown is completely different than any other town that contracts with Waterbury. Again, because we're expressly and implicitly named as a user of that water. And again, that legislation requires rates that are just and equitable. And I've just been reminded that Wolcott is actually suing Waterbury over the sewer rates that Wolcott's paying. But again, those towns are completely different. Watertown paid upfront its share of the capital cost of that plant, for the sewer plant and the water plant. So Watertown is much different. No other town has a percentage ownership participation in all the capital improvements over the last 40 years. So again, the amount of water or sewage capacity that's involved in those other contracts is very, very small. And Watertown's position is we're completely different than those other municipalities.
Ms. Monet, you have 15 seconds left if you'd like to ask.
Yes, thank you. I actually do agree with you, Mr. Pelosi. Watertown is different from the other municipalities because they're not on the hook for $18 million. Thank you very much.
Thank you. Is there anyone else online who would like to ask a question?
Jack Flynn.
Mr. Flynn, go ahead. You have a minute.
Yes, can you hear me? Yeah, Jack Flynn, 526 Mount Fair Drive. Attorney Pilsey, when you were going through the history, you mentioned there were times when Waterbury used monies that were supposed to be allocated for the water system and put it into their general fund. Is that correct?
I can't hear you as clearly as you may be speaking, but I believe you're asking if Watertown's opinion is that Waterbury misappropriated funds from the filtration plant construction to its general fund. If that's your question, the answer is yes. That was done, and Waterbury acknowledged that in the settlement from 2007.
Is it possible for them to use any monies coming from these rate increases and put it into their general fund?
I think your question is it possible that they're still taking water revenue and putting it in their general fund? I have no knowledge of that at this time. I don't think they're doing that. I do believe they are operating the water system at a deficit, and they're supplementing the water operations out of general fund dollars, which is another cause of concern to Watertown because it tells us that their rates are going to be subject to a market increase in the relatively near future, which again means if Watertown does not challenge the methodology of these rates, Watertown can never challenge them again, but will be paying all of these future increases that we know are coming relatively soon.
Right, and therefore, after this presentation, I agree with you. I don't think we have any choice but to challenge this. Because if we just, I understand that there's a possibility that we could lose. There always is. But if we don't challenge it, we've already lost. And we're going to end up paying the rate and any future rates. And by acquiescing to it, we're acquiescing to the system that says Waterbury says what the rate is and you got to pay it. So I agree with what you're doing. Thank you for your presentation.
Thank you.
Thank you, Mr. Flynn. Is there anyone else that would like to ask a question online or make a statement? Is there anyone else that would like to ask a question online or make a statement? Thank you. If somebody who asked a question prior would like to ask another, or ma'am? Yes, ma'am.
My name is Elizabeth Bushkin. I live at 514 Sylvan Lake Road, and only in the past 5 years have we been hooked up to water and sewer, which is very hard to take that. I've been here from the very beginning. Many people have already left, but I hope that the rest of the people who are still waiting are going to recognize that they must hear from the town council tonight. I had a very pleasant conversation with our vice chairman of the town council. Both of us, I think, walked in hoping that we are going to learn a great deal. And of course, I did learn a great deal, and I think that Mr. Burns, going back all those years, is something that we needed to hear in order to know how to position myself. But unless Mr. Pearson is going to bring this case to court to the next level, as he had explained, I think that we need to hear from Mr. Jessel and from the town council as to what you're planning, because otherwise I walk out tonight in believing that none of you know anything about this, just the way I don't know anything about it, that you're hearing this for the first time, and that folks who are on the payroll and are elected officials have already started thinking what is to be done. So I'm appalled that we're going to be waiting for another case. I'm appalled that everything that might happen, very well laid out. But you know, there's a tomorrow and another tomorrow. And what happens in a year may be very different. And today, this evening, it is everybody except, I believe, Mr. Pilacy, who is holding responsibility to tell us, the ratepayers, the taxed people, the ones who are interested. That's fine. I'll give up my 15 seconds, but I'd like to see you give up the 15 seconds on telling me what you're going to be doing from today on. Thank you.
Just for a point of clarification, the council and the Water and Sewer Authority are not in meeting. They're not here to engage. It would constitute a meeting, which would mean that we violated FOIA laws. I'm sure the council will take that under advisement to make a determination on whether they would want to do that in a council meeting, but an answer will not be coming from either council or commission, just for clarification. Sir, did you want to?
George Stearns, 29 Orchard Lane.
Sir, would you just speak a little bit closer?
Okay, George Stearns, 29 Orchard Lane. What I would like to ask is if Watertown, Waterbury go into negotiations, how is the dispute going to be solved? Is there an arbitrator involved in this? Or is it just, if there's no agreement, what good does it do?
Every dispute is resolved by agreement of the parties or a court order. Waterbury has not offered to even discuss an agreement other than take the rates that we've established and pay them. So Watertown has had no choice but to seek a court order to resolve this dispute. Again, we hope, we have some reason to believe Watertown will be successful in court. That will not set new rates. That will simply say that the rates that Waterbury established right now are not correctly established, and Waterbury has to come back and will be forced to negotiate a new rate structure with Watertown. That's what we are hoping will happen through this court challenge.
And if they don't negotiate after the court decides that what's currently existing,
I
Is not
can't
right?
answer that. It largely depends on what the court decision says. If the court decision simply could say that Watertown doesn't have to pay the rates that were charged. And then both parties are back where they were at the end of the 2013 contract. That's probably as good as it's going to get. The court may use other terminology. The court may specifically order the parties to negotiate new rates, or the court may simply say that the rates established by Waterbury in 2015 as retail rates are not appropriate for Watertown's rates. Therefore, at some point, we hope and expect there will be negotiations with Waterbury.
thank you.
Thank you.
Is there anybody else that would like to speak for the first time? Otherwise, I'll move on to those that would like to speak for a second. Last time for online, first time speakers. Thank you. Anybody who would like to speak a second time, please come to the podium.
Catherine Camera, 31 Cottage Place in Oakville. I have a question that I would like to have the answer to online as my last one, and I believe it's something that everybody in this audience would like to know. I want to know how much we have spent in legal fees and costs to date for everything involved with this matter. That would be Attorney Jessel, that would be Mirtha Kalina, that would be Attorney Pillacy, that would be experts. There's a lot of costs involved with this, and I believe everybody here should know. It should be online. I asked for this information through Freedom of Information back at the end of July, and it was ignored, and I had to file a complaint. I believe we need to know how much we've spent so far. How much does something like this cost us? Because that's not just a ratepayer charge, that's the entire town. And another thing that's going to involve the entire town, we keep hearing that this is only the ratepayers. It's our taxes that pay your fees. And tonight we're paying attorney fees. So another question that seems to, people think that because they're not ratepayers, that they're not going to be charged anything. Well, how about this building? This is a public building. It uses water. The town hall uses water. All the schools use water. Isn't that then something that the taxpayers are going to be paying when those fees go up? So when we go and we say, oh no, it's only the people who have water and sewer who are going to be charged. You know, these are questions that are not getting answered. There's plenty of questions that we would like answers to, but now we're told tonight you don't have the answers, that you can't speak, and that's not what we thought was going to happen here tonight. So I guess we're going to have to, it would be a very good idea if you then allow us a place online that we can ask questions and get answers to, so the whole public can get these answers, because we're not getting them tonight. Thank you.
I can answer part of your question, and that is that all public buildings that are connected to water or sewer do pay water and sewer rates, including fire hydrant, fire protection rates. And you're correct. The municipal charges are passed on to everyone in their tax bills.
Thank you. I'd also like to make clarification that Ms. Camara did request through Freedom of Information the billing or the legal fees, and she has not been denied. The town is still working on producing those documents, just for clarification. Is there anybody else that would like to speak? Yes, ma'am.
Catherine Dinsmore, 35 Reynolds in Watertown. I'm reading from the press release that was sent out. The public forum will include presentations from legal experts familiar with the case's intricacies. Additionally, representatives from the Watertown Town Council and relevant municipal departments will be present to provide context and answer questions from the attendees. And Mr. Ramo, just previously, you just stated that they are not here to do that.
Just for clarification, what I stated is this is not a meeting. And that if we did allow them to conduct business, it would be constituted a meeting. So
But Mr.
when
Ramo,
you
it
are
does say
100%
that in the, I'm respectfully. You are saying this is not a meeting. However, in the press release that was sent out by the town of Watertown, it clearly states that the town council members and relevant department individuals will be present to provide context and answer questions.
Yes, so you are correct, and I made a mistake when I wrote that. I should have been clearer on how I did that, so I apologize.
Perhaps it should have been addressed in the beginning of this because we were misled.
Is there anybody else that would like to speak?
Richard Rosansky, 35 Reynolds Street. Clearly, the town did not practice good financial risk management. We knew, Mr. Pillacy has stated that everybody knew, the town council, the town manager, Water Sewer Authority knew we were underpaying the invoices for 5 years. Every month, those invoices would come in, and yet we did not put enough money aside to pay the bill. Now, Mr. Pillacy is saying we could take up to another 24 months for this to be heard by the Supreme Court. We're accruing over $9,000 of interest every day. We are underpaying our invoices every month. So doing simple math, that adds another $8 million onto the 18.8 that we owe Waterbury, that the ratepayers are on the hook for if we lose this appeal, if we lose this to Supreme Court. What about financial risk management? What is this town going to do to protect us, the ratepayers, who on average, if we all use the same amount of money, right now, each of us have accrued $4,100 in arrearages. If we all use the same amount of money, we know we don't. That's not a really good number. But nonetheless, we're going to add another $8 million on it. How are you going to protect us from a financial risk management standpoint if we lose this case?
Is there anybody else that would like to speak?
Charlie Shields, 141 Merriam Lane. Was just wondering, after this is all settled, there were a long-term contracts and agreements with Waterbury before. The last couple have been 5-year terms. What are the options going forward? Is there an option for another 5 years? Is it a longer period? Is that negotiable? Or are we just talking about getting out of this year and starting all over again?
The big problem with this case is that Waterbury has refused to enter into a long-term contract that is traditional for water and sewer services. Again, the first water contract lasted from 1939 to 1988. The 1988 contract was a minimum 25-year contract with 2 automatic options to bring us to 35 years. The 25-year contract is more typical, and Watertown did not willingly agree to a 5-year contract. Watertown was offered a 5-year contract at a very favorable rate that was deemed just and equitable. So to go to court or to not sign that contract would have meant that the same case we're in now, we would have been in at that time. But it made no sense at that time because Waterbury was charging a rate that was just and equitable and actually quite reasonable and in fact lower than water rates in most other parts of Connecticut. So there was no opportunity, nor did Waterbury get as aggressive with, in our opinion, improper rates until after the 2018 rate expired. Again, Watertown for over 5 years has been willing and actively seeking to negotiate a new contract with rates that are negotiated by both sides in good faith, and Waterbury has refused. I think the how long that's going to continue,
Up and ask that so everybody can hear.
I can repeat the question. I think the question was, how long do we expect that situation to continue?
Well, how long would that new contract, could we expect that new contract to be? Another 25-year contract?
Well, a contract has
short?
to be agreed to by both sides. If my recommendation would be that we seek a minimum of a 25-year contract with typical escalators. Again, the 25-year contract doesn't set the rates. It sets the methodology to determine those rates. So there can be increases over time as the components or portions of the Waterbury system that Watertown uses cost more to maintain and so forth. So those contracts have built-in increases, but it's based on, again, a methodology that's cost-based.
And that's fine that they have, I can understand they have increases built in, but the longer period we know what's going on, the better is all I'm trying to get at.
If Watertown has a cost-based contract, it really doesn't matter how long it is. If Waterbury said, we're going to give you 5-year contracts, but they're all going to be cost-based, it wouldn't make any difference whether it's a 5-year or a 25-year. But I do agree with you that I think a 5-year contract is extremely unusual in the water business and sewer business. We would always look for a minimum 25 years if we can get it.
Thank you.
Frankie Popolowski, 5 Chestnut Avenue. I am finding that some of my neighbors are trying to sell their properties, but with this litigation going on, they can't sell because the new owner, from what they understand, has to pay all this rate because it hasn't been settled yet. So who's going to want to buy a property that they're going to owe thousands of dollars for water and sewer on?
I don't think that's a question that I can answer.
Well, who can?
I don't think anybody.
Because it's
can answer that.
affecting anybody that wants to sell their property that has water and sewer. And they're in the middle of this mess that you all created, not us.
I reject any notion that anybody at Watertown did anything to create this mess.
So how do we sell our properties if we owe thousands of dollars?
I do acknowledge that that is a real issue, but I do not believe there's any easy answer.
Is there anybody else that would like to make a comment or a statement?
Evening, Dennis Buckley, Beach Avenue, Watertown. I kind of came in late, so I'm not really too sure what's been discussed before, but just being a lay person who reads the paper every day, I just really can't understand why the people here in Watertown thought that they were and should be able to pay a lower rate than what Wolcott, I think, in Middlebury and what everybody else has agreed to pay. I'm not really too sure why we felt that we deserved to pay a lower rate than anybody else did. To me, it's very, very confusing. On top of that, I'm not really too sure why we feel we have the right, or you felt, sorry, not we, you felt you had the right to tell Waterbury that we are paying this amount. It's their water. They have the right to charge you what they feel is a reasonable rate, and that's what Middlebury, Wolcott, and somebody else is currently paying. So I really don't understand why we're taking this to appeal. I think you clearly lost the case.
I think the only people that are going to get rich on this are going to be the attorneys, Mr. Jessel, whoever else is going to be representing, and nobody else. So why, I don't know why you're carrying this on. If I was you, and I'll have a disclaimer. I'm related to the mayor, and so I want to say that in case, he doesn't know I'm here. We don't talk about it at all. I think the best thing you can do is to crawl to your knees to the city hall in Waterbury and negotiate a rate and somehow figure this whole thing out. Because as somebody said before, the longer this goes on, the only people getting rich are the attorneys. And it's just doesn't make any sense to me. First of all, we have no right. We didn't have any right to tell Waterbury what we wanted to pay for their water. And here we are in a huge mess. And it makes completely no sense to me as a layperson. Thank you very much.
Anyone else that would like to make comment? Otherwise, is there anybody else online?
Jack Flynn.
Mr. Flynn, your second comment, go ahead.
Yes. Okay, yes, as a taxpayer and a ratepayer, I'm concerned about the $18 million back bill and what might be accrued as we appeal. However, this question's for Attorney Pilsey. If we win the case, that $18 million will probably be substantially reduced, correct? If we go into a negotiation. Hello? Can you hear me?
Yes, Mr. Flynn, was that a question or is that a statement?
I'm asking Attorney Pilsey if the $18 million that we owe and any more that we will accrue during the court case, if we win and it's ruled that we must go into negotiations, that will be reduced, wouldn't it?
If Watertown wins the court case, the most likely result is that Waterbury will be required to sit down and negotiate new rates with Watertown. It's certain in any new regulations, Watertown would not be required to pay any interest. And whether or not Watertown agreed to a retroactive rate increase as part of those negotiations, which would use up a portion of the money that's been set aside for this case, that would be subject to negotiations at that time.
Right, but Watertown wouldn't be negotiating to pay this 18 million, which is based on what you have stated you consider an unreasonable rate, correct?
I didn't hear your question, sir.
Okay, if we go into the negotiations, I wouldn't think that Watertown would agree to the $18 million, which is based on what you consider an unreasonable rate. It would be based on whatever the negotiations come up with as the reasonable rate that both Watertown and Waterbury agree with. The point I'm trying to make is, then I'm concerned about the back bill, but the obvious thing to do is to fight this so that the back bill may not be as large as it is now. Otherwise, we're going to agree to pay 18 million and whatever rate Waterbury wants to give us, which
That's
I
the whole
consider
point.
unreasonable.
The whole point of the court case is to achieve rates that are cost-based and reasonably related to the cost that Waterbury incurs in delivering water or having water accessed by Watertown, which is that's the rate methodology that's been in place for a minimum of 78 years prior to the 2018 contract termination or ending. So we have a time-tested 78-year methodology of determining or establishing rates between Watertown and Waterbury. And then that whole concept was thrown out the window by Waterbury. And we believe that that was improper and not based on any statutory authority.
And I agree with your presentation. And all I'm saying is, if we win the court case, obviously, because there's a lot of concern about the $18 million. And like I said, I'm concerned too. But the way to get that reduced is to fight the case and try to win.
Mr. Flynn, you have 15 seconds left.
No, that's it. I just wanted to make that point. I'm concerned about it, but I'm not just gonna lay down and pay it.
Okay, thank you. Is there anybody else that has, yes, ma'am? Okay, well. Okay, Ms. Manette, please go for your second turn.
Yes. Hello, can you hear me?
Yes, ma'am.
Yes, thank you. I think my question would be directed to the town manager. And Mr. Ramo, do you as town manager feel that this was the most proactive step to take to move forward with litigation? And do you feel that maybe something of this magnitude should be presented to the town citizens for more of a consensus on whether or not to move forward with litigation?
So as the town manager and having the understanding that I do have the case, I was not involved when this case went to court.
Understood.
So, but I do feel very strongly that we are a bulk rate customer. We maintain our own system. And I think it's important that the council and the Water and Sewer Authority has taken the leadership role to ensure that the ratepayers get a fair deal. As I said in my other comments, that we are great partners with the City of Waterbury as they are to us, but we do not agree. And I stand with the council and the Water and Sewer Authority and our town attorney in that this is the right decision for our town. I do want to disclose that I have water and sewer at my house, but I do have family members that do live in town that do pay rates. So I am concerned as well.
I understand, but do you think that something of this magnitude, as far as the litigation and the scale of money involved, should be something that the citizens should have had a voice in pursuing for a long-term litigation action? Don't you think that, I mean, do you think that would be a better way to get more support for what the end goal is?
Again, you're asking me to comment on something that's already occurred.
I'm talking more of the present, though. Because you're the town manager when we're moving toward an appeal, and as Mr. Pillacy had stated, what the goal is as far as ongoing litigation. As a town manager, do you feel like this should be something that the town citizen should have more of a voice in whether we should pursue this or not?
I think that the only thing I could tell you is I am fully supportive of open and transparent government. I may have handled this a little bit differently, but I'm not here to critique anyone who was in the seat that made the decision at the time. That's the best I'm going to answer that question for you.
Okay. And then my last question is, there was the issue of authorizing the short payment of invoices that were coming in from the City of Waterbury. Presently, are those invoices still being short paid, and who is authorizing them to be short paid?
So yes, we are not paying the amounts that the City of Waterbury has stated they set. We're still paying the original rates back from 2018. There were letters that were sent to the city on numerous occasions asking for us to mediate this issue. And the authorization came from the Water and Sewer Authority. And I can't answer if it was also in conjunction with the council at the time. I was not present.
Okay. But who is actually at the end of it authorizing the short payment? Who is signing off on that? Is that a collective as the town council signs off on it being short paid?
You're asking me to, it's an issue that's in litigation. This advisement by our town attorney and the attorneys that are representing for this case.
Okay. So they would need to answer that question then, or it can't be answered?
Well, I'm not quite sure what exactly you're trying to get to. I
Who
mean,
is authorizing the short payment of invoices to the City of Waterbury?
the decision has been made by the town council to move this to an appeal. So the decision was made prior to me sitting in this seat. I don't know who made that decision. And I could just say that I'm not changing that decision as the sitting town manager.
So you're authorizing the short payment of the invoices to the city of Waterbury. Thank you very much, sir.
You're welcome. Is there anybody else that would like to speak? Yes, ma'am.
Again, my name is Elizabeth Bashutinsky of 514 Sylvan Lake Road. I think when I spoke first and you answered Mr. Ramo, you told me and everybody else that in fact we are learning at the same time. Even more important, as the meeting started, I think it was Mr. Pilisi who told us that there was paperwork that we could pick up at the back of the room and take it with us. I think everybody who wanted the paperwork has picked up that which is in this room. But what I'm struck with is that all of us in this very, I think, not tedious, but very important learning session have heard and perhaps have even thought about it, including all of you at the head table, that there's so much more paperwork that has passed through the years, which sets the case as it was told to us. But even more important, the most recent year since the last contract has been signed in 2018, there's even more important paper that builds the new appeal and the new information. I would urge all of you as members of the town council, as the authority for the water and sewer and for the attorney help that is being provided, that you think of it and to think of us as helpers, as people interested, as somebody who needs to be engaged in this resolution, however long it's going to take. And certainly something which is important for us is to continue learning. Please, if there are papers that should be added to the large group of papers that has already been dismissed, please put them on our website. It is ludicrous, and I think almost criminal, to think that we're going to sit home and to pay for the information questions, all of us individually. You are the leadership. Tell us what you think we should know. Tell us that way that we will be able to read it when we also want to learn more about this case. And I'm talking about specifically the period from 2018, where all of this started in the most recent epoch.
Thank you. Is there anybody else that'd like to make a comment? Otherwise, I'm going to close the meeting. Anyone else like to speak? Are we clear online? Okay, we're going to call this meeting closed for the evening. We appreciate you coming out. We'll do our best to put out the information as we can. Thank you.